And then that committee member, of course, looks into it as he deems and sees fit.
How large a group do we have in that district?
You mean as far as the
members of the committee?
Members and an area that we serve?
Well, it serves 4 counties, and you have representatives, both attorneys and laypersons on the committee. The actual number is about, I think, 12 to 14. It varies, depending on the number of laypersons. But like I say, it serves a 4-county area, and we have representatives from each county.
I still feel somewhat hesitant to come to a group of attorneys to solve a problem with attorneys. That's what makes me feel uncomfortable as a layperson. Okay, in coming to this, you say there are lay people on the non-attorney. Lay people? Is that how you say that? I don't know how to. Non-attorney people, regular people that are also on this committee. How does that work as far as a balance of the decision? Is it weighted toward the attorney side, or how does that work?
I don't think it's weighted, and probably you'd have a difficult time without having attorneys on the committee to explain some of the problems that attorneys routinely run into that give rise to the vast majority of complaints. But I think the laypersons who serve on this committee are much more sympathetic to the plight of attorneys in their practice after they've had an opportunity to see the type of complaints and the way they arise. But I can assure you that attorneys are critical of other attorneys in this capacity.
Well, it's just to help each of you, that everybody's working on the up and up, that you don't, because, if you talk about an attorney, it's kind of like when they talk about that deacon of the First Baptist Church, they don't say which one, it casts a shadow on everybody. So it's the same thing with attorneys.
It's bad enough as it is.
How are you selected? How long do you stay on it? Are you permanent? Are you monthly? How long?
It's a 2-year term, and you're actually nominated by the state director of the state bar and appointed by the state bar. And your term can serve. Some of the folks that have been on the grievance committee have been on there for years and years and years. My predecessor was on there for about 10 or 12 years.
It's probably one of those things he probably said, let's pass this good thing around.
I think exactly so.
It takes up a lot of time. Sometimes it does. You have to properly investigate a case. You do have to take up a lot of time. Of course, no one's compensated for being on the committee, so you can understand why you wouldn't want to serve for a lifetime term.
There's got to be some kind of gauge, though, that you could have every crackpot in the world coming up there filing. Every time an attorney loses a case for somebody, they could say, well, there's a sorry attorney is the reason here I'm calling y'all up, and y'all go through all this process of investigation. Is there any certain level of problem that y'all can automatically say, hey, I'm sorry, we can't handle your situation, you're just a nut, and there's no case there? How do you select which you do or do not carry through grievance?
Well, first of all, I think the most important thing there has to be an attorney-client relationship. There's some grievances against public officials that we don't have any jurisdiction. Say if a person had a complaint against a judge, that's handled by a totally different group of people with the bar. But the basic thing is that we pretty much catch everything. We have to screen through all of them. I mean, some of them have merit to them, some of them have no merit whatsoever. And we just sit down at our monthly meeting and go through them, discuss them.
So you do go through every complaint,
right,
whether it has merit or not,
right,
at the meeting of the committee.
Right.
What is your most common grievance that comes up before the board? Are you referred to as a board or just a committee, I guess?
Committee, I think is probably the most common. I think the most common complaint arises out of a failure to communicate between the attorney and his client. Some folks perceive the way their lawsuit or the way a legal matter should be handled very subjectively. And probably the greatest fault that most attorneys have is not being just straight out blunt with their clients from the very beginning. And probably, I think the most common conflict arises from the failure to communicate between the client and the attorney, and sometimes clients have unrealistic perceptions of what their matter the way it should turn out.
What about even understanding? I know I probably would have trouble, communicating with you and knowing, you told me one thing and I thought it meant one thing.
Sure.
So that would that's probably why the lay people are on the board, the committee, to help with that. How are they selected, the lay people?
They're also nominated. I think, practically speaking, they're nominated by the chairman of the Grievance Committee. But of course, officially, they're appointed by the state bar.
Well, the state bar would know people in Shelby County who would, if you pick somebody out of the hat, you might get somebody that was one of those that come up every month.
I think the laypersons who serve on there are extremely sympathetic, well, not extremely, but in most cases, you get a much better understanding of the way things really work, and are more sympathetic to most attorneys that practice and everything like that. It's kind of like a plumber sometimes that, if I call him, I just say, just fix it. I don't want to know how you're going to fix it, just fix it. And sometimes lawyers will do the same thing, and I explain to their clients the pros and cons and the realistic evaluation of the way things may turn out. And the clients are disappointed because they view their situations very subjectively, and as I would were I a client.
I think I've heard it more, and this here I'm negatively inflecting toward another occupation here, but I've heard of like doctors. That we've all seen all the movies and all the stories, and the medical profession is real protective of other doctors. And other doctors will not talk negatively of another doctor and they protect all that stuff. I don't know whether that same type of thing exists inside the legal profession also. But what I'm saying is, our attorneys very hesitant to jump on another attorney, to go for legal sanctions against an attorney or reprimand or public humiliation or this, that, and other. Is there, because of course you want the legal profession to be respected. You're an attorney and I want the profession held up.
I don't think we're hesitant at all in the committee. Of course, what goes on in the committee meeting is totally secret. That is the first and foremost thing is that we're not allowed to talk about various cases. But it's been my experience that all the committee members, all the lawyers as well as the laypersons, if a lawyer is guilty of some ethical consideration of violating the canons of ethics, we're one of the first ones to jump on them for that violation.
I think the reverse is true. I think fellow lawyers are probably more critical. But by the same token, they want to be fair because they encounter the same situation.
Right. That makes more sense to me because that way, the more ethical the profession in the long term becomes, even though you got a problem, you'll wind up with a better respected profession.
How would the process happen? Okay, I contacted the committee or I contacted Alton and eventually it would come back down to Shelby County. You would know if we fill out the grievance form. Would I appear?
Well, not necessarily. It just depends on the various grievance and how serious the nature is of the grievance. But first of all, the way I handle it, and I think the way every other committee member handles it, is first of all contact the other attorney that's involved and forward a copy of the grievance to him or her to look at it and to give them a chance to respond to it. Once there's been a response made, then the committee member gets back in touch with the party that's making the grievance. And at that stage, usually a lot of the grievances are worked out to everyone's satisfaction. If it's not worked out, then of course the committee member reports back to the committee, and it's left up to the committee whether or not that should go on to a formal hearing or not before the full committee, where there is sworn testimony taken from both sides. Both sides are given an opportunity to air out their problems that they have or whatever the particular grievance is, and the committee members, of course, are allowed to ask all parties any questions they have to make. Even though it's kind of handled on a quasi-judicial basis, it's still rather informal, kind of like a roundtable discussion. And then, of course, after the formal hearing, then the committee will decide on what action to take, if any at all, against the attorney.
What extent, what can you do to an attorney that has, what power does this committee have? What's the worst thing you can do? Is it financial? Can you charge fines and penalties, or a rebate of legal fees to a client, or any damages dollar-wise, or disbarments? What's the extent?
Well, they can recommend the whole gamut from a mere informal reprimand. Of course, if there's no merit to the complaint, being dismissed. But to the recommendation of this bar, of course, you have to go through a trial and legal process in order to disbar someone. But the committee has the power to recommend the entire spectrum of punishment, I guess you would say. It holds a lot of power in its hands as far as recommendations.
Short of disbarment, there's perhaps too that people don't very much understand. There's a private reprimand, which the attorney is given a reprimand for his actions. There's a public reprimand that is published in the State Bar Journal. His name comes out in the Bar Journal, what he did, and what the results of whatever the punishment was. But like I say, you got to understand this can't all be appealed to the state bar level. Anything the committee does can be appealed. And there's very few times that I've been in my experience. I think there's just one that I know. Of course, I haven't been on the committee as long as Grover, but I know one that's just been appealed. But most of the times they're resolved on the committee level.
That's something that you probably don't want done, to be printed in your journal.
Right.
Is it, can your committee, I guess you can't, or do you have the power of ruling against an attorney if they agree to the, it's not like, I'm getting arbitration all confused with this thing, the power of the committee. Is your level of power just through a recommendation to settle the thing, or do y'all actually have power to say, you're going to pay this client back his legal fees, and he has to pay this dollar amount?
Practically speaking, yes, I think the committee has that power from a practical standpoint.
Right.
I don't know of any attorneys
no attorney can be dumb enough.
If the grievance committee made a recommendation that some ethical conduct has been violated and recommended that that be done, I don't know of any attorney
who wouldn't respond. What happens, say you reprimand him privately, just in the committee, and then that happens again? The same attorney comes up, same type of problem. Do you have any problems like that, or does usually the private reprimand usually take care of that situation?
Well, of course, if it continues, the little things that we can constantly reprimand them for, of course, the reprimand can become public, and then, of course, if it gets bad enough, of course, we can recommend stiffer sanctions.
But is that something that usually happens, or usually the private reprimand serves its purpose that you intended it for?
I think so. I think that's usually, that pretty well takes care of any problems in the future.
Have you ever faced as a committee any attorneys that maybe come back the second, third time? And it's not the attorney's technical legal problem.
I was just fixing to say, the number of complaints that an attorney has filed against him does not mean that he's an unethical attorney.
Right.
There are some attorneys who have more complaints filed against them by the very nature of the business type of practice that they have. But by way of example, the number of times that a doctor gets sued down to malpractice doesn't mean that he's a bad doctor necessarily. Right. It just means he may have a very busy practice, and he may be in an area where lawsuits are a little more.
What about the problem that y'all originally talked about? The majority of the cases were with lack of communication. What about attorneys that just are not good at communicating with the clients? They just are maybe very quiet people.
Well, they're going to have more of those complaints usually against them. That's just the nature of the situation, because most folks who, at least in trial work, I think that Guy and I are most familiar with, are extremely subjective about their lawsuit. It's a black or white situation to them. If you're in an automobile accident, and from our viewpoint it may be a gray area as to who has what degree of liability, but if you're in the accident and you're hurt, or your children are hurt, or your wife's hurt, someone like a member of your family's hurt, you're not going to see it in shades of gray. You're going to see it in black or white, and you're going to be pretty firm about thinking that this guy's at fault. Now, if your attorney doesn't sit you down and say, you have to be realistic about this, and this is the law, and explain to you that I may not be telling you what you want to hear, but I'm telling you the truth about and being realistic with you about the situation and about the potential of your claim here, then you're going to get some problems. If something happens that you lose your case, most people, I think it's human nature to look for a scapegoat. Now, it may be the attorney's fault, but many times an attorney, as with a physician, has to make a judgment call. It may not be the right judgment call in that particular time.
What about the Attorney Grover that is just real adamant about, boy, you got a case, yeah, I think we can do this, out of the, when you first come to see it. And everything's just wonderful. He researches the case, and boy, we've got a case, we've got it down, etc. You get to the courtroom, and all of a sudden negotiations begin. And all of a sudden, well, I don't know. We can go a little bit farther on this, well, I don't know. And you're sitting there going, what you've been paid? That to me is one of the, to me that's ethically wrong for fellow.
I think it is, and I think that most important to avoid getting to this stage at all, and that's what you want to do, is to avoid getting to a stage where you've got a grievance and have a problem of that nature, is that a client shouldn't be afraid, just in the nature of the medical profession, to ask his lawyer questions if he doesn't understand. When he first comes in there and his lawyer starts telling him all this, I'm going to do this and that and this and that, slow him down. Ask him questions. What does this mean? What will be our next stage? Don't be afraid to call your lawyer and ask him what's going on in the case. A lot of times in trial work, like Grover mentioned, there'll be many occasions that really an attorney doesn't need to contact his client to consult with him. There's a lot of preliminary work, a tremendous amount of work that goes into a case before it gets to the trial stage. And there may be a month, 2 months that goes by that the attorney, or maybe even longer, that the attorney never contacts his client. The client said, well, he must not be doing anything. If that's the stage, just call up the attorney and ask him what he's doing. Regarding fees, if you don't understand the power of attorney that you're signing, have him explain it to you. If the lawyer can't explain it to you, then of course you may need to go talk to someone else. If he can't communicate that to you. But I think the most important thing is to keep those channels, as Grover said, of communication open. That's, in my experience that I've been on committee, that seems to be 90% of the cases that come before us that could be avoided by communication.
Yeah, you brought up a good thing, though. There's this gray area there that exists just between the lay person and the legal counsel. You just have an understanding as a professional of the different implications and the way that this is interpreted, this and other. There has to be that gray area of total trust that a layperson has in an attorney, there in that area, that the layperson will never understand all the implications. There's no way you possibly could. That's why I go to an attorney, for one reason. I'm just talking about, is there that gray area that the Grievance Committee would lean toward considering that an attorney was doing bad by not revealing the total truth of, I guess I'm backing up that same
Let me give you an example, Wayne. Suppose I represent you in this fictional automobile accident, and there's a witness that we know of that you want to call in your trial. And I've talked to the witness and judged what the witness will say. And in my judgment, he has the potential to say something as harmful to your case as he does to say something that would be helpful to your case. That's a matter of judgment for me, and I feel that's really my decision as to whether or not to call that person as a witness for you. Now, I may be wrong, but I'm not unethical. And this is another thing. I think we've actually seen this in some cases before, where someone say, well, he didn't call this witness at my trial. Well, then that very well may be true, but that's a value judgment by an attorney who has presumably years of experience and who has been in the same situation before, and who has to make a value judgment as to whether or not that would be to your benefit or to your detriment. And there may be both. It may be a slight tipping of the scales. And sometimes folks will, if they lose, they would tend to say, well, if we'd called that witness, if he'd have just called that one witness, which may not be true. You might have won if he'd called the witness, but you might have lost as well. And you see that type of complaint made sometimes. Now, in that case, I'm very sympathetic to the attorney. I think he probably should have set that person down and talked with him more thoroughly and said, this is a value judgment that I have to make on your behalf, and this is the reason why. And sometimes lawyers are bad about not, they get busy, they get involved in it, of not being patient and sitting their clients down and explaining these things to them. If we're guilty of something, it's probably not going into a lot of detail. Many times just saying, you have to trust me on this one. I think that's the source of many complaints. Now, that's a gray area, but I think that's not an ethical standard.
Okay, so if I've got a grievance, if I'm ticketed an attorney today, the first step you say is go talk to that attorney and try to get something done. Second step, if there's just no way of working out the problem, I get hold of one of you two here, okay, and say I've got a grievance, and it will something be considered on that.
Right.
I'll get an answer of some
Certainly
sort.
will.
Okay.
And y'all meet every month?
Every month.
Every month.
That's great. Because I can imagine how many backlogs would if you waited for any length of time.
Well, listen, appreciate you guys coming this morning, and hope we don't drum up any business.
Y'all probably gonna get a dozen calls this afternoon.
Hey, listen, we'll be back in just a minute. Going to have a little short word, and then we'll be returning with another fine guest.
This is Bill Rogers, producer of the Coffee Shop Cafe. On behalf of our entire staff here at the First Baptist Church Studios, I want to thank you for tuning in to our program. It is our purpose to bring to you, through our guests each week, both the lighter side of the events and activities of this community and the more serious issues of the day. It is our policy to keep all broadcasting in good taste and to present the issues in a fair and constructive manner. The Coffee Shop Cafe is intended to be informative, not argumentative. We welcome your comments and your suggestions. Our program committee chairman is Buster Bounds. He and his committee have the responsibility for planning our programming and securing our guests. If you have a topic which you believe would be of interest in Center and throughout Shelby County, please contact Buster Bounds or our host, Wayne Christian and Shirley Shofner, or me, Bill Rogers. Thank you again for tuning in to the Coffee Shop Cafe. Now let's go back to our host and their guests.